Hello, Prof.
Thank you, Samson.
Great. Good to hear you. I'm very good, sir. Thanks for asking. So the majority decision in the conclusion said that we reject the invitation to reinterpret or effectively rewrite these constitutional provisions to imply that an incumbent member of parliament shall not file nomination to contest on a platform different from the one on which he was elected unless he first vacates his current seat. Such a reading imposes an undue restriction on political freedom, a constraint not articulated in the original text of the articles. The constitutional language should be construed holistically and purposively, without imposing limitations that could curtail the fundamental freedoms of sitting MPs and ultimately sabotage the rights of the electorate. Isn't this a fair reading and interpretation of the provisions, that their declarations and their filing to contest is for the future? It does not affect the current parliament. And they continue to do business. They have not changed their character by which they entered this parliament. So they should not be punished for it.
I have subscribed to the future or the futuristic aspect of the provision as the court concluded. So the court's position is one that I've subscribed to, and I've actually said this on your network in the past before the judgment came out. So I'm very much of the view that the decision really should be about the present and not the future. However, the reason the court ascribed to it, with the greatest of respect to the courts, is extremely problematic. Now, the reason it's problematic is precisely the reason of political freedom is what the Constitution seeks to constrain. The Constitution, in essence, is saying that if you go to Parliament on one promise, you do not have the pleasure, you do not have the freedom to change willy-nilly as and when you wish. In other words, while all of us can change our political alignments, members of Parliament can only change their political alignment on the pain of losing their seats and having to go back. And so for the court to therefore rationalize this on grounds of political freedom and the right of choice of a member of Parliament is to undo precisely what the Constitution seeks to prevent, i.e. the fact that you can stay out of Parliament and change your party anytime you want. That's your business and that's your prerogative. But if you're in Parliament, the promise on the basis of which you went to Parliament, you cannot change anyhow. And that is partly the difficulty, again, I have with another aspect of the decision, which I have to say, by the way, the judgment is nicely and lucidly written. I enjoyed reading it in terms of the lucidity of the articulation. But there are a few problems with the judgment. Another problem.
The one you just mentioned, let's stay there for a minute. It says MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. You say this is a wrong statement of the law?
No, that's what I've said. I've said I actually subscribe to the futuristic aspect of the change. In other words, the fact that the change must be to your current membership of Parliament, not your future.
Okay, so Esiama,
I subscribe to that theory. The point I'm making is the rationalization of that I found problematic with respect. And the reason I found problematic is what I've already articulated. The fact that basing it on the freedom of choice is in my opinion, and with the greatest respect to the court, not an accurate statement of the law in this case, because the freedom of choice of an MP is constrained. The MP doesn't have the same flexibility and latitude that we have to make choices of our political alignment. MPs don't have that. MPs must stick with the parties with which they went to Parliament for purposes of doing business in Parliament. And that's what I was going to state about the other difficulty that I have.
So you are saying that if you are changing, you are in the known that you are sacrificing those freedoms. Is that what you are saying?
That's what it is.
Okay.
In other words, the Constitution doesn't allow the changes and the exercise of the political freedom of choice. The Constitution doesn't allow that for MPs for purposes of being in Parliament And that's what I was still going to,
Still stay there. Stay there briefly for me. Stay there.
That difficulty.
Stay there for a second.
Difficulty, because it's important to understand that for purposes of this something, otherwise this one is not complete. It's a point I'm making. It's connected.
All right.
I'm saying the other difficulty.
No. Hold on. Let's just clear this before you move there. When the judgment says that MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. My question is, Andrew Esiama, for example, he is independent doing business with the NPP. Now, he has filed on the ticket of the NPP. He must be a member of the NPP before he can file on the ticket of the NPP. Has he changed political allegiance or he has not?
Well, that's the point I was going to make. And that's why I said it's a completed, it's a complete set of analysis. So I'll be grateful if you can allow on this. So the point I was going to make, therefore, is that as I read the judgment, I realized that the court did not speak in the positive term. The court spoke in the negative term. Now, in the negative term, in the sense that the court actually told us what does not constitute vacation of seat. What I did not see in the judgment is the positive statement of the circumstances that constitutes the vacation of seats. I think the positive statements would have been very helpful. And that's the question you're asking, which is what I've been trying to say all along.
Is this not the positive statement?
Imperative.
Is this not the positive statement when they say an MP must vacate their seat if they leave the party under which they were elected to join another party or become independent and seek to remain in parliament under their new political status?
Correct. That's positive. But the question is, what constitutes the leaving the political party? That is a broader statement. In fact, if you look at the contestation in parliament, it seems that the proposers are saying that they have left the party. The opposers are saying they haven't left the party for purposes of the current parliament. And so it would have been helpful to understand what constitutes leaving a party. Now, I can hazard some guesses, and I have to be clear. I'm not a court, so I'm just speculating at this stage. But we can hazard some guesses. For example, who does the member of parliament do business with? Where does it sit? How is his name captured in the Hansard? How does the clerk of parliament capture him in the various parliamentary transactions, records, and administrative processes? How is he even captured by the speaker when the speaker when he's trying to catch the eye of the speaker? Generally, what characterization and what association does he bring to bear in terms of he being in parliament? In other words, the constitutive element of leaving the party is a factual statement, and that factual statement is made up of elements that I would have been grateful or happier if the court had actually itemized those. I think as we stand at the moment, we have still not resolved that big fundamental question. And for the future, this thing will arise again. What has just happened represents a precedent that I'm sure other parties will replicate. The next time another party is in majority and the other is in opposition, and we have a situation of independent candidature declared, we are going to have this possible scenario again. And therefore, it should have been imperative that we have a definition, a detailed definition of the constitutive element of what represents leaving the party. Because that's the expression that the Constitution uses. So the Constitution
what represents